Just want to welcome everybody to our CLE today. This is part of the Practice in a Flash series. Thank you so very much for coming. I'm going to just kind of launch right into it. Today we've got an esteemed colleague of ours, Phil Wormdahl. He graduated from the University of Utah Law School in 2009 and immediately went out and started his own practice. And so, as you're aware, a lot of this Practice in the Flash program is designed to help those of us in the profession that are in that similar circumstances. So Phil's a great example of somebody who went out, learned the practice area, and now he's ready to give back and share some of that with you guys. He's also a famous member of a U2 cover band, but I'll let him tell you about that if he wants. So everybody, big hand for Phil.
Thanks a lot. As Gabe said, I'm Phil Wormdahl. I'm a University of Utah grad, and having been out only 2 years, I'm far from an expert in criminal law or DUI, but I've learned some things along the way, probably like most people. The only reason I know more than maybe somebody who's just starting out is because I've happened to ask those questions to people who know the answers. So that's basically where all my education about DUI has come from. It's just calling up attorneys and asking them, or asking judges or prosecutors as well. So I would encourage everybody to, if you need information, you can always call me. I'm totally fine to talk to people if you have a DUI case and you need some help with it, or second guessing yourself. But there's a lot of DUI attorneys around. There's a lot of DUI focused attorneys as well as criminal defense attorneys who do DUI and who can answer your questions. So of course, as a young lawyer, you should be thinking about cultivating those relationships and having a good network of experienced attorneys that you can talk to. I haven't been to any of these talks before, so that maybe will be beneficial to everybody, or maybe it'll hurt the continuity of the series. I don't have any handouts. I don't have any big presentation. I know that I'm supposed to kind of give like a good overview, like the 36,000 foot view of DUI from start to finish. But I'm certainly okay with kind of gauging the temperature of the room. If people in here, the majority of you have zero criminal defense experience and really want to understand the sort of basic mechanics of how criminal proceedings go, that's fine. We can talk about that. And if most of you have experience in criminal law and want to talk more about strategies, or how do you handle this at trial, or how do you handle this pre-trial, just let me know. Feel free to shout out questions, or divert where I'm going to a different area if the group kind of wants to do that. So first of all, as Gabe said, I went to private practice immediately upon graduating. Well, not exactly immediately. I was putting out resumes, got sworn into the bar. I actually applied at the prosecutor's office in Salt Lake City and didn't get the gig. And I just kind of realized I could continue to put out resumes and job hunt, or I could just start working. Being a lawyer is different from being a doctor, and the overhead in terms of starting up a criminal defense practice is pretty small. You don't have to go buy an X-ray machine or get a big staff in order to be a criminal defense attorney. Really, so long as you have a research account and an office and a computer and a copy machine, you can do it. So I think when I first started, I sort of went into it thinking, if it doesn't work, I can continue to look for a job. But as it turned out, I was able to get enough clients that I didn't really have time to send out resumes, and it just sort of snowballed from there. That's maybe a good segue into why I do criminal defense, DUI in particular. My feeling is that DUI in particular, and maybe some other misdemeanor type offenses in criminal law, sort of lend themselves to building a client base. People who get a DUI, I think a lot of them are likely to have a friend who may get a DUI in the next year or so. Because obviously people are going out in groups when they go out to bars or go to parties or things like that. So if you do a real good job and you have a happy client at the end of the process, if that person's friend gets a DUI, I think that you can count on them calling you. So that was sort of an unintended consequence of doing DUI. I got really interested in DUI, number one, I guess because I'm a drinker and the DUI laws here kind of bother me. For instance, in Utah, if you're driving and you get pulled over and an officer says that he smells alcohol in your car, he can pull you out of the car and do field tests on you. So that's a pretty low factual threshold for getting somebody out of an automobile, standing on the side of the road, on the side of the freeway in the middle of the night, in the cold, in the rain. I mean, I've done the field test before, so I can tell you it's not a pleasant experience. I've never been arrested for DUI, but I've done the field test on a few different occasions, and it's no fun. It's incredibly stressful and frightening, and police obviously are carrying guns, and it can be difficult. So oddly enough, as I said, just the odor of alcohol under some Utah cases is going to allow a cop reasonable suspicion that you're DUI and then get you out of the car. One of the things that I think is kind of interesting and odd about that is that it's not illegal to drink and drive in Utah. It's only illegal to drink too much and drive in Utah. So it's odd, you may remember from your criminal law cases or from experience in criminal law that if the reasonable suspicion is essentially articulable reasonable suspicion of criminal activity, right? But drinking and driving isn't criminal activity, right? At most, an officer who pulls you over, smells alcohol, detects no other signs of impairment or anything else suspicious. Really what he has is suspicion that you've been drinking, not that you're impaired by alcohol. And I have argued, usually unsuccessful to judges, that the absence of all those other factors that would indicate impairment count into that totality of circumstances and should cut against a finding that somebody or an officer has reasonable suspicion to get somebody out of a car. But as I said, unfortunately in Utah, that's just not the state of the law. And the cop says that he smells alcohol, he can pull your client out of the car or you out of the car. So without further ado, I'll launch into kind of an overview of how DUI works. DUI is interesting because it's sort of a hybrid criminal, civil, administrative area of the law. And the civil stuff that happens at driver's license division usually happens before anything's going to happen in court. So I think that that's a good place to start. When somebody's arrested for DUI, they have 10 days from the date of the arrest to request in writing a hearing from driver's license division. That hearing is their only opportunity at that stage to protect their license. If they don't ask for that hearing, their license will automatically be suspended for the arrest at the end of 30 days. So again, that's another thing that really aggravates me about DUI laws. You're not innocent until proven guilty in the administrative sense. If you're arrested, it's presumed that you were DUI by the administrative agency and they yanked your license. That suspension for a first offense DUI is 120 days or 4 months. And as I said, the only way to avoid that at that phase of the DUI process is to request that hearing in writing from the DUI section. Civilians can request those hearings the same as anybody else. As an attorney, if you request it, I would recommend that when you request the hearing on behalf of your client, you ask for discovery ahead of time. Driver's License Division will then send you at least the items that the officer sent to Driver's License Division to start the process. So that'll be some, things like the DUI report, which I'll talk about a little bit more. If there was a blood draw, they'd probably send you the chemical test results if they have it from the lab. And sometimes ahead of the hearing in the mail, you may get certification reports for the breath machine that was used in the case. Sometimes they don't have toxicology from the lab until the day of the hearing. Sometimes they don't give you certification reports from the intoxilizer machine until the day of the hearing. So every case is a little bit different in terms of what you'll get up front. But the most critical thing is just to request that hearing. The hearing, after it's requested, it will be scheduled within 30 days of the arrest. And the reason for that is that when somebody's arrested for DUI, their driver's license is taken by the police officer and sent back to Driver's License Division. And they're issued, in the form of their DUI citation, they're issued a temporary driving license. So that temporary license, which is the citation, is valid for 30 days from the date of the arrest. And so due process basically is then requiring that hearing has to be within 30 days because they can't take the license, they can take the physical license, but they can't take your privilege to drive without giving you due process. So once you've requested that hearing, you need to have the hearing before that temp expires. If for some reason you or your client can't make a hearing within 30 days, you can waive that right and extend the hearing out. But if, for instance, the police officer can't make it because they're on vacation, their only flexibility is to move the hearing, more proximate to the arrest in time because they can't break that 30-day rule. So, as I said, usually that administrative hearing within 30 days is going to be the first thing that happens in the case because the case won't have been filed or won't be set for arraignment until after that. Those hearings are informal adjudicated proceedings. You can look in the Utah Code for the rules that govern those. You can actually also, I believe, just look on the DUI citation. It probably has a cite to those rules. It's 63G something something. I'm not sure the rest of the cite. But it should be a quick search if you want to find it. So at these administrative hearings, as I said, they're informal, and they're informal not only in official name but in function. It's just about the most laid-back thing you could imagine. You literally just kind of go out to one of the DMV offices, or DLD offices, sorry. I correct my clients all the time. DLD and DMV are actually two separate agencies, so that's important to remember too. If you're calling them DMV, you're probably wasting a call. So you go out to the DLD, and you just go into an office with a hearing officer who, as far as I can tell, is not law trained in any way. This is just on-the-job training. You sit down at a desk. Your client may be present if they choose. They can call in telephonically if they would like to do that. Or you can just appear on behalf of your client. Your client need not be present. So long as you're there, your client doesn't need to be, but obviously if your client's representing themselves at the administrative phase, they would need to be there either telephonically or in person. Additionally, then, the officer is going to be there. My experience is that the vast majority of the time, officers are going to appear telephonically. The exception would be that there's a handful of officers, highway patrol troopers and municipal officers that I've encountered that choose to attend in person if they can. My impression is that they feel like they want to take away the sort of the strategic advantage that you get as an attorney if you appear in person. And I believe that there is an advantage to showing up in person. For me, it's just easier to manipulate documents and to make arguments to somebody that I can actually see. Also, I think that for whatever reason, something about my presentation is lost over the phone, and I think I usually come off sounding like a jerk over the phone. So it's easier if I can smile when I tell the hearing officer that the police officer's wrong. So I would say go to the hearings. The hearing usually lasts for about an hour. It kind of, just in terms of the components, it's sort of like being in court. The hearing officer will read an opening monologue that just explains the purpose for the hearing, the documents that are going to be part of the record, and administrative things like that. They'll then do a direct examination on the police officer, who is essentially just going to read from their police report. I mean, literally, if you have the DUI report in front of you, you can just see them reading through it through the phone as they're quoting it directly and just jumping from section to section. At the end of that, sometimes the hearing officer will ask questions for follow-up on the officer. And in terms of the follow-up questions, it really depends on where you are. All these hearing officers are hugely different. You cannot tailor your argument for a particular hearing officer until you've been in front of that hearing officer. They all have sort of their own little pet peeves about things that happen in the course of arrest that are going to maybe sway them one way or the other. So that's something you just kind of need to learn from experience, or ask somebody who's been in front of that hearing officer, hey, this is the issue that I see, should I try it? Some of the hearing officers, kind of getting back to my point, they'll ask follow-up questions like, now officer, I'm sure that during the observation period you observed the arrested person for the entire period, right? And you're just thinking to yourself, really? Really, this is how we ask questions as the detached magistrate at this hearing? Great. But some of them are much better, and they'll say things like, how did you conduct the observation period? So you'll just have to watch and see. Like I said, all the hearing officers are different. Some of them will essentially put all the appropriate testimony in the officer's mouth. Some hearing officers will try to do that, but the officer essentially won't let them if they really don't know what the hearing officer is asking. For instance, I did a hearing in Farmington several months ago, where the hearing officer, who I find to be quite good up there, actually asked the question about this observation period. And I'll talk more about that in a minute when we talk more about the substantive DUI stuff. She asked the officer how he did the hearing, how he did the observation period, or, I'm sure you did the observation period, right? And the officer basically just said, what are you talking about? It was great. It was one of those beautiful moments that criminal defense attorneys don't get too often, so I relish it. So after the direct examination and the follow-up questions by the hearing officer, you can have an opportunity to cross-examine the police officer. And I always tell my clients that the number one priority at these hearings is to help you keep your license. But the number two priority is to build the record. This is essentially, for people here who practice civil law, this is like my chance to get a deposition of the arresting officer. It is awesome. Different hearing officers, again, are going to give you more leeway than others in terms of the questions that you can ask, but this is a great opportunity to fill in details that are missing from the DUI report so you can learn something. But it's also a great opportunity to marry the officer to the report, asking questions like, now officer, you've reviewed your DUI report throughout this hearing, right? Yes. In fact, you've been using it to answer all the questions on direct, right? Yes. And in doing that, you've had an opportunity now to review its accuracy, right? Yes. And at this point, is there anything about your report that you'd like to change? No, it's all right. All the times are correct? Yes, they're all correct, right? Really nail them down to all that stuff. And the reason is because if something changes in the case and you find yourself in a hearing with that officer, you want to make sure that the officer can't do anything like, oh, I forgot to put that in the report, but yeah, this is what happened. Right, so you want to ask those questions. Everything that's important is in the report, right? Nothing in the report needs to be changed, right? It's particularly important in cases where officers, they'll write a narrative report that describes your client as being like, no, he wasn't falling down drunk, but he seemed like he'd been drinking. He didn't do great on the field test, so I breathalyzed him and he blew over the limit. And in Utah, if you're .08 or above, you're DUI, and so here we are in court. The issue then is if you do something amazing like get a breath test or a blood test suppressed from trial, you leave this officer in a position where if you haven't really nailed him down, he can start saying, well, I could tell he was drunk. I sure wouldn't have wanted him on the road based on his physical appearance and his performance on the test, right? They're going to rely on that chemical test if they've got it sometimes, so you want to force them to do that in a case where you feel like you may have a suppression issue. So you need to be thinking about all that stuff at the driver's license phase. You want to learn as much as you can about what you don't know, but you also want to make sure that the officer is tied down to that. In addition to being under oath at that hearing, the officer is also being recorded on tape, on digital tape. So at the end of one of those hearings, whether you win or lose, you're going to want to request from driver's license division a copy of, one, the findings of fact from the hearing officer, and two, a copy of the audio from the hearing, because that will be used later. You can impeach an officer with extrinsic evidence at trial by way of that audio. And as I'm sure you can imagine, using audio in front of a jury or a judge to impeach somebody, it's one thing to have a criminal defense attorney impeach somebody on the stand. It's another thing when they themselves are impeaching themselves with their own voice. It's amazing. I did a suppression hearing in Draper a few months ago where I had an officer who did precisely this. He had described the driving pattern of my client in a particular way in his DUI report, in his narrative report from Draper Police Department, in the probable cause booking sheet, on direct at the driver's license division, and on cross-examination at the driver's license division when I asked him, like half a dozen variations of the same leading questions. This is the driving pattern you saw, right? It was just like this, right? And literally completely changed his story on the driving pattern at the suppression hearing. I just turned the audio on and played it for the judge, and it was incredible. Again, you don't get those victories a lot as a criminal defense attorney, especially in Draper. So when you can get them, it's awesome, and having the audio is just absolutely critical. So requesting that is as simple as just sending a piece of paper that says, I'd like to request the audio from such and such hearing, here's the driver's license number, and you have to send a $5 check for the audio. The findings of fact, which are the written findings from the hearing officer, so you can find out what it was that made them suspend the license, or what it was in your argument that made them not suspend the license. Other critical things if you ever want to do another administrative hearing in front of that hearing officer. Those are free if you're the attorney of record at the hearing. If another attorney does the hearing, or the defendant is pro se at that stage, you're going to need to pay $5 for the written findings as well. But if you were there, you get those for free. So next, talk a little bit more about discovery. A lot of the discovery, like I said, you're going to get at the DLD phase. So things that you probably won't get at the DLD phase, though, are dash cam videos. Not all police have dash cam videos. Most highway patrol have dash cam videos. Some municipal and unified have dash cam videos. Pretty much none of the Salt Lake City PD has it, which is incredibly frustrating. But yeah.
Can I just ask a quick question before you move on?
Yeah.
On the DLD phase, I was stunned when I learned what that probable cause is the standard of review for the stop. What's your success rate for? Because I can't imagine it's the standard is horrible.
Sure. Well, first of all, yeah, the standard's difficult, and a good practice point if you want to do DUI law, or I would say any type of law, you don't want to overpromise and underdeliver to your clients. So you should be making absolutely clear to clients at the outset that administrative proceedings are, number one, just sort of a joke in terms of procedurally. I mean, for instance, the hearsay rules don't apply. I mean, the rules of evidence actually don't apply. The only sort of evidentiary gatekeeping that's done is due process. Like, would this violate due process? And I could go off on that all day. I mean, DLD calls it gets toxicology reports, against your client. They're the finder of fact, and they're collecting evidence against your client. And the statute says that the officer should deliver all that. I mean, it explicitly says it. But anyways, so yeah, the standard of proof is really low. Probable cause is maybe one way to put it. In practice, the way I would call it is, if it's reasonable at all that the officer got your client off the road that night, then you're hosed. So you need to find some sort of strategic ways to deal with that. And in terms of statistics, before I talk about strategy, in terms of statistics, first of all, Department of Public Safety publishes statistics about all of this stuff. So it's on their website, and rather than get into my, my rates or whatever, I'll just tell you that they're difficult, you do your best. Check out Department of Public Safety. 30% of the time, or like 28% of the time in 2010, according to statistics that were released this spring by Department of Public Safety, officers don't show up. Officer doesn't show up, hearing doesn't happen, license is kept. So just by requesting the hearing, you have almost a 1/3 chance of keeping the license. Now, one thing to keep in mind is that that's statewide, and it's not dependent on the police agency involved. So my personal experience tells me that if I have a client who got arrested by Salt Lake City PD and their hearing is going to be over at Fair Park, I tell them that they would bet the farm that cop's going to be there. I've heard that it has something to do with pay raises and pay grades being determined in part by participation in driver's license hearings. I don't know that for a fact, but for whatever reason, they're there, like every time. I think maybe one DUI I've ever had with Salt Lake City PD, they didn't show. Highway patrol, on the other hand, is probably the most likely not to show up in my experience. I haven't kept statistics of my own on highway patrol, but certainly it sticks out in my mind as the law enforcement agency that's least likely to show up at an administrative hearing. I don't know why that is, if they're changing.
There's a trooper that lives on my street, and I'm only guessing, but when he's working swing shift, he's sleeping during the day.
Right, and that's what I was going to say. I think they changed their shifts, so your DUI squad guys, right, they're going to be, if you get a DUI hearing right in the middle of the day, you may be catching them when they're sleeping. I'm quite positive that I've dealt with law enforcement officers who are at home. I mean, you can hear their kids and stuff in the background. I mean, it's their day off, or they should be sleeping, or whatever. Sometimes they'll call in, but I think you could be right. It could be a number of factors, though. It could be that. It could be that UHP, especially their DUI section, does training for other municipal police officers on a regular basis. But frankly, I just don't know. I'm just glad when they're not there. So it's a bummer to lose the discovery opportunity, but of course it's better to keep the license at that point. It gives you a little bit more flexibility later in the process too, if you can get over that hurdle. What I was going to say though, for strategies then in the driver's license hearing, you need to pick your strategies wisely, right? I mean, if you have somebody that did marginally on field tests, you're probably not going to argue that there was no reasonable basis to have that person blow. right? I mean, unless they ace those field tests, you're in big trouble. So, for instance, I had a guy who was above the decision point on the eye test, the HGN, but passed the other 2 tests. And I think odor of alcohol was maybe the only other factor for impairment, and had a hearing officer say, no, that's not enough, that wasn't reasonable, even though the person did blow over the limit. So, and that's another question that's actually fuzzy in my mind, is whether or not, even though these hearing officers have the result of the chemical test, if they're using that evidence to justify the arrest. My suspicion is that they are, but I'm not really certain about that. Maybe it could be that there's situations where if they're thinking that the arrest was marginal, kind of marginal, then they'll look at that, and if it's over, then maybe we'll sway them, but frankly, I don't know, you have to be a mind reader. So for strategies, as I said, you're looking at, you can try to kind of win on the merits of the arrest, right? Or you can look at procedural things. And frankly, that's where the bread and butter is in winning these things. It's procedural issues. So for instance, I mean, I can name off a couple, but you're just gonna have to do a little research to figure out the rest. But things like, you have to give the person notice of the division's intent to suspend the license. So that means the citation, and on the citation, there's a box that needs to be checked that indicates, hey, person holding this citation, we're gonna suspend your license if you don't come have this hearing. So that they need that information. So for instance, if the officer doesn't serve them with a citation or doesn't check the box, this is particularly important on cases where people refuse the chemical test, because that's a separate hearing called a refusal hearing. So somebody can refuse the chemical test, but if only the per se box is checked, the DUI box is checked, and not the refusal box, then the hearing officer, it's improper for them to proceed to do a refusal suspension because the box wasn't checked, because that notice requirement wasn't met. So procedural things like that are important. Always watch times in DUI reports. For instance, I dealt with a lot of chemical tests at administrative hearings on timing issues where I don't have the video yet, but I see that the police officers indicated that they started the observation period where they're supposed to have uninterrupted observation in the presence of the arrested person for 15 minutes. They'll start that observation period, and then 5 minutes later, they have in their report that they're starting the inventory search of the vehicle. I mean, clearly you can't be searching somebody's car and observing them in the backseat of your police cruiser at the same time. So if there's no other officers present, then that's a great argument to take care of a breath test in an administrative hearing. So watch times, make sure the boxes are checked, look at the admonitions. Whenever somebody gets arrested for DUI, the officer has to read certain admonitions to them, explaining one, that by blowing they're subjecting themselves potentially to a license suspension if they're over the limit. Two, that they have no right to refuse because of the implied consent laws, and if they do refuse, that there'll be additional license consequences. And then also there's what they call the right to counsel admonition, which is something that's read if a person says, well, maybe I'll blow, but I want to talk to my attorney first. They have to point out that you don't actually have the right to counsel for that part of the arrest or for the decision of whether or not to blow, because that's a civil issue, not a criminal issue. So an example of what I mean by watch those admonitions. If somebody, let me see how I can break this down. So I want to say, I had a case once where it was a refusal case, but the person read Miranda to my client before they had them blow, before they'd agreed to blow. So imagine, maybe it's easier if I just say imagine this in your mind. You're sitting in a police station, you're freaked out, you don't know what's going on, and the cop Mirandizes you. Boom, you're like, oh yeah, I'm hearing these rights. Now I know that I have rights. And I find that people presume that they don't have their Miranda rights until they hear them, because on TV they think that Miranda attaches when the cop reads it to them, not when they're in a custodial interrogation. So these people, they hear that and they think, okay, I've got rights. I have the right to an attorney, I have the right not to cooperate. They lock that into their brain, and then the cop reads them the refusal admonition and says, no, you don't have the right to refuse. And they say, well, yeah, I do, and I want my attorney. And they say, no, you don't have the right to an attorney. But they've already been Mirandized, right? So that's very confusing. So sometimes you can win a refusal hearing based on, look, that's not, even though this cop read the admonition, that admonition isn't good enough if he's already Mirandized this person, because this person legitimately thinks that they have the right not to cooperate. So that's not fair. That violates due process, those types of arguments. Any more questions about driver's license hearings? We can move on. Okay. And of course, if you have questions, I'll give everybody my email address afterwards. You can always feel free to call me or email me and find a follow-up on any of this stuff. So you want to get dash cam videos when you can get them. Those can be critical, right? It's cool to have a screwed up time on a police report, but when you can actually see the cop with his butt sticking out of your client's car, digging through all the stuff during the Baker period, during the observational period, that's awesome. Again, because most of the time, even when they do stuff like that, they say that they did the observation period. So if you get a cop who says, yeah, I did it, and then you show the video and you go, oh, really? Okay, maybe I didn't do it. And Baker is a requirement for administration, or excuse me, for introduction of a breath test into evidence. Dash cams, you can get them by subpoena, by grammar request. You just kind of have to call the law enforcement agency that's involved and get their sort of, whatever their preference is, and then do that. Summit County Sheriff is a pain. They won't respond to subpoenas or grammar requests in pending cases, so the only way to get a dash cam in Summit County is to have the prosecutor get it for you, which again is an incredible pain, because by the time the prosecutor is doing discovery, the driver's license hearing has come and gone, and your person is either without a license or driving on a suspended license. Any questions about discovery? I mean, that's pretty much it. I mean, you do your discovery requests to the prosecutor's office. You subpoena, what other places are involved. I had a DUI in a 7-Eleven parking lot, so I got security camera footage through subpoena from that step. So you just kind of have to use your head in terms of being a little bit of an investigator. Court, then the first hearing is what's called an arraignment. If you don't have criminal law experience, basically in a misdemeanor case, you go in, your arraignment is you're just entering a plea. So you're going to say, I'm guilty, I'm not guilty, or no contest. If the person's represented by counsel, counsel is going to send in a notice of appearance, of course. What I always do in my notice of appearance is, of course, notify the court that I'm the attorney, but I also do a few other things. One, I plead my client not guilty. I ask that their arraignment be struck and that their case be set for pretrial. Another thing that I would always do is assert my client's right to a speedy trial by a jury, an impartial jury. Speedy trial right is one of those things that if you don't request it on the outset, it's difficult to argue that you've been denied it later. And there's a case in Utah, I can't remember what the name is, but it gives some factors for like speedy trial, and you have to say one of the factors is when did you assert the right to a speedy trial? So you want to do it right at the beginning. At that point then, the court, most of the justice courts here will just strike the arraignment, and they'll call your office to set a pretrial according to your calendar. So functionally, the pretrial is then going to be the first appearance that you make in court with your client. Under Rule 13, I think it is, of the Utah Rules of Criminal Procedure, you can actually waive your client's appearance at a pretrial conference. It's their right to be there. There was a push in the legislative session this year to make that subject to judge approval. I don't think that passed, so I think still your client doesn't technically have to be there. I find that you always want to let the court know ahead of time, though, unless you're in a court where you know that they don't really care if your client's there, because some judges have been known to issue bench warrants and stuff like that for people who don't show up even if their attorney's present. So at the pretrial then, you should have all your discovery. You should have looked at it comprehensively, and you should know essentially what you're going to do with the case. You're either going to settle it at the pretrial conference through a plea, or you're going to start thinking about motions to suppress if there are any, or you're just going to set it for trial if there's no motions that you need to deal with. So maybe I'll talk about plea deals first, because that'll be a little bit quicker. So in Utah, of course there's all kinds of plea deals that you can do, but the big two are basically you're either going to plead a DUI with sentencing recommendations, or you're going to plead to impaired driving, which is sort of like what people would call alcohol-related reckless. That's sort of the colloquial term for it. Utah doesn't have that anymore. I think it was 08 when they got rid of that. So now they have impaired driving. The major differences between impaired driving and DUI are in the criminal court, the fine is going to be a little bit less. Usually you're not going to have supervised probation on a impaired driving. Sometimes on a DUI you will, most of the time you will, sometimes you don't. It kind of depends on if you have sentencing considerations from the prosecutor. Jail is not mandatory on impaired driving. That's another big one. 48 hours of jail is the mandatory minimum for a DUI conviction in Utah. Some judges will allow community service in lieu of jail if you can argue for it or get a stipulation from a prosecutor. Other judges absolutely will not do that. For instance, Judge Bound out in Riverton will not let you do community service and move jail. So first time DUI in Riverton, you are going to do 48 hours in jail, period. Last but not least are the driver's license implications of those pleas. This is a place where there's some overlap between the criminal law and the administrative law. So if you enter a plea and are convicted of DUI, not impaired driving, any conviction for DUI will make your client interlock restricted. It doesn't matter if the court orders it. If they're convicted of DUI, they're interlock restricted for 18 months. There is nothing you can do about that I've ever heard of. They're stuck with it. I've been thinking of creative ways to try and get around that, like doing reductions later. There's a criminal statute, 765402, I think, where you can reduce a charge to a lower level. So a lot of times what people will do is they'll like plead to a third-degree felony, and at the end of probation then reduce it down to a Class A so they don't have a felony on their record. The code actually specifically says that an impaired driving is a reduction of 1 degree under that statute. So I've considered potentially, if somebody was in that situation where they finished probation after 12 months, did it successfully, that you could move to reduce it down to an impaired, and then maybe try and float to driver's license division, like, hey, this isn't really a DUI, it's an impaired driving. But I suspect that wouldn't work. I haven't tried it yet. I actually just thought it out last night. So, at any rate, interlock is the big one for DUI. Jail is the second one. So, like I said, those are the two trade-offs. There's some other marginal difference, like with the fine and some other, probation characteristics, but those are the big things. Whether or not you get an impaired driving, yeah.
I'm sorry, I don't really understand what interlock is.
An ignition interlock is a device that needs to be installed in your car that prevents you from starting it until you blow into it and blow zeros or blow under a certain threshold. I think in Utah they're all calibrated at 0, but I don't know that for a fact. Most likely they are because, again, if you're convicted of DUI or you're convicted of impaired driving or you lose your administrative hearing, then the driver on a first offense is going to be an alcohol restricted driver for 2 years. So meaning it's illegal for them to drive with any amount of alcohol in their body, period, for 2 years. And quickly I'll just say, I'm not going to go off and do a big thing about underage DUI. That's something to keep in mind too. Sometimes a municipal prosecutor will charge a youth with DUI. So you have the 19-year-old kid gets charged with DUI, blows a .06. Technically, that person is not per se DUI, because DUI is .08 or above. It doesn't matter if you're under 21. What that person's really violating, most likely, is that they're an alcohol-restricted driver, right? And that's an easy case for the government to make at trial. They blew a .06. They need to blow zeros, right? And in fact, I'm not sure about this, but I almost feel like it's measurable or detectable amount of alcohol. So if an officer came in and said, I detected alcohol on his breath, then technically your person could get found guilty under the statute. But you can use that distinction sometimes to your advantage. For instance, if you get a prosecutor, as I said, who will charge somebody with DUI and with alcohol restricted driver, thinking that because the person had any alcohol in their body, or maybe they just charged maybe they just charged DUI. But if that person's a .06, and you can show that they weren't too impaired to drive because they did okay on the field test or they look okay on a video, that's a mistake in charging by the prosecutor a lot of the time. They should be charging alcohol restricted driver. So sorry for that aside, but that's worth mentioning. So any questions, other questions about plea deals? And obviously if your case has big problems, you can get better plea deals. You can get like a straight reckless, pay your $500 fine and go home kind of stuff, or even less. I had a cop, it was a Kaysville City cop, it was his first DUI arrest ever. On New Year's morning, this guy blew, according to the machine, blew a .19. This is the officer at the administrative hearing who said something like, "What's the observational period?" So we had all that stuff, and actually, a credit to this officer, we actually just powwowed before the suppression hearing, prosecutor, officer, and me, and just talked about kind of what happened and what he had said at the administrative hearing, and he just owned it. He said, yeah, I really screwed up. He said, I wish I could go back in time and do it again. So we actually didn't even have the hearing. My guy ended up pleading to public intox, which is a $130 ticket, Class C misdemeanor.
Can you talk to the officers outside the presence? I mean, are they considered to be represented? And
No, I think they're parties, to be honest. And I don't have this all flushed out in my mind. There's sort of some weird rules about how police officers fit in, because like for instance, under the discovery rules, I think it's either under the rule or under case law, like Brady. The police are considered part of the prosecution. So for instance, if the police department has some document or something that the prosecution doesn't disclose to you, and it's exculpatory, for the purposes of Brady or for the rule, wherever it's coming from, that's actually in the prosecution's file, even if they don't have it, if it's at the police department. So yeah, you can talk to cops.
but they're not considered to be, I mean, even though they're part of the prosecution, they're not considered to be represented by counsel in that context, so you could just call them up. And you don't have to
This
go
would
through
be a
the
great
process.
opportunity to whip out your bar card and call the ethics hotline. I'm pretty sure that you can. But in this case, just to cover me for the video, the prosecutor is there. But I mean, I talk to them on the phone at driver's license hearings all the time to cross-examine them, and there's no, they don't have counsel there. So I think they're part of the prosecution. I think it's akin to just talking to a prosecutor about the case. So, and of course, it's a fine line to cross, whether or not you want to talk to them at all, right? I mean, showing your hand is obviously a strategic decision that you as the attorney can make alone, right? Sometimes you want to do that, sometimes you want to blindside them. So it's just really up to you and your discretion and your feel of the officer and your client's wishes. So, yeah, that's plea deals. So basically you find yourself in a position at a pretrial where you either have a great issue and it's worth it to go after it, so some sort of big issue for a motion to suppress or a motion to dismiss, in which case you wouldn't want to take an impaired driving or some other plea. I mean, the plea would have to get pretty awesome if you had like a really good issue that you wanted to try. But a lot of times, ultimately, what you end up with is plead guilty to DUI, and we'll recommend no jail. We'll recommend community service and no jail. This is especially going to happen in cases where you have a BAC that starts getting up like upwards of 0.15. Or sometimes prosecutors, if your client refuses, they won't give an impaired driving plea, which I think is really weird. Because obviously their case is hurt by the fact that they don't have chemical evidence. So I would think that they would be thinking of that, but I think those prosecutors are thinking, I'm not going to do anything for your client because they didn't cooperate. But at any rate, if your decision is plead guilty to DUI, that's not really a deal, right? I mean, that's not an offer. Like, I'll dismiss the $90 ticket for not using your blinker long enough if you plead guilty to DUI and have an interlock in your car for 18 months. And I've had clients that have told me before, I'd rather go to jail for 48 hours. Quite honestly, I think I'd probably rather go to jail for 48 hours. I mean, how many of you would rather work for free for a week? I mean, think about what a financial opportunity cost is lost, as a practicing attorney, to give up 48 hours of billables doing community service. Maybe you want to do community service anyways, but the point I'm trying to make is that for a lot of people that's not an offer at all, in which case your case may absolutely stink, but take it to trial, right?
Sometimes they might have already done the 48 hours in jail anyway before they get bailed out.
Good point. That happens quite often. Yeah. Some people can't bail, especially if it's a second or third offense. They're going to do some time right off the outset before they get out. Highway Patrol's policy, from what I understand, is to book people into jail after they're arrested for DUI. They move from that policy sometimes. For instance, I had an officer who was at the end of his shift and wanted to go home. And then it was great because his printer in his cruiser actually broke, and so he couldn't print the citation. So he actually had to take my guy down to the special ops and print out the citation anyways. He was so frustrated on the dash cam. But at any rate, yeah, they may have already done the jail. And the municipal cops, typically that I've seen, they cite and release. So it's like, if Salt Lake City PD picks up your client, they'll pick them up, they'll call one of the other officers on the motor squad to show up with the intoxilizer in their car, and they'll have you just blow on the side of the road, and then they'll say, call a sober friend. You just come pick them up, they tow your car, and you go home. So, and actually, whether or not you've been booked into jail or not is something that you would want to mention to a judge if you're arguing at sentencing. So for instance, like she said, if a prosecutor offers me, I'll recommend no jail, we go to trial anyways, case is a dog, we lose, as we sort of expect to lose, but we're not going to give up. I'll argue to the judge and say, let this person do 48 hours of community service. They've already done 16 hours in jail, right? They were booked, they had that experience. If you're concerned that they need to go to jail to learn their lesson, they did, right? They had that humiliation, they had that experience, they've learned their lesson, and frankly, judges, the only reason we're here is because there was no offer. So, and I don't think judges typically are going to punish people for asserting their right to a jury trial anyways. I would hope not, in my experience, I haven't really seen it. So, that's sort of where you are at the pretrial phase. And actually, I think that's why DUI sort of has been nice for me, especially when I first started, is because it kind of takes some pressure off of you in terms of, is this a good deal? Should my client be taking this or not? I mean, literally, it's like, is it important to you to have an interlock in your car? They're like, oh, absolutely not. I can never have an interlock. That would be like the end of my life. And I go, you may want to take this impaired driving then, because your case is uncertain. You never know what a jury's going to do. If that's the most important thing to you, then you probably want to do that. You probably want the impaired because you're not going to have the interlock. But if a person is just offered, DUI, well, my job's done, right? You can either give up and plead guilty to DUI, or you can go to trial and you have a 90% chance of being convicted, and a 9% chance of a mistrial and a 1% chance of winning. What do you want to do? So, and sometimes that pays off, and I know it's annoying to do war stories all the time. Yeah.
So just a follow-up question to that scenario. Does the price of your law services factor in when you explain, look, your odds of winning are really low. Do you want to pay me to go to trial? Is that an issue for most clients or do most clients just...
Yeah, it could be. I mean, to be quite honest with you, sometimes I do trials for free because I'm so annoyed at the prosecutor. It's just like, I know you don't want to pay me, that's fine. I want to do a trial anyways, right? Because if you win, I mean, you got to be thinking about, Sim Gill said to me, if you don't like the deals that prosecutors are giving to you, start winning cases against them. Watch how good the deals get, right? I mean, you have no right to a plea deal, so I mean, if you want a good plea deal, start winning. Make good arguments, try some cases. Take them to task and see if that changes them. And of course, maybe the opposite could happen. You start trying a bunch of cases, and prosecutors don't want to do anything for you. But at the end of the day, that prosecutor has to make a decision: is this a case I want to take to trial, or don't I? Right? They don't want to waste the judge's time if it's a slam dunk. So maybe that's the way to get to an offer. Another case was a .18 with an accident. There was no offer. Well, it was stay out of jail. Like I said, I don't care about jail. So we went and did the trial, and it just blew my mind. My argument kept the breath test out. I literally was just hoping that the judge would say, that's not an admissibility issue, that goes to weight, you can argue it to the jury. I mean, literally all I was trying to do was have the judge authorize me to discuss it with the jury beforehand so that I could do it. And she suppressed it. She wouldn't let him introduce it into evidence. And we got an offer for an impaired, pay a fine and go home at lunch. So, and it was awesome. Unfortunately, in that case, the prosecution in their opening had already talked about the breath test result. So my alternative was a mistrial because they discussed evidence that they couldn't admit, or take the offer. And such was the case in this trial, that it was a defect with the admissibility that they could have corrected had they had another bite of the apple. So we just went ahead and took the offer. But like I said, that was one of those cases I was like, dude, you got 1% chance of winning. So let's do it. And he was happy. Talked a little bit about sentencing. I talked about some of the driver's license consequences, the biggest one being the interlock. Another thing to know about pleas and sentencing is that if you lose your driver's license hearing, the suspension starts. If you enter a plea to impaired driving and then send the docket and the order to DMV, they will reduce the suspension to 60 days from 120. So if your client's driver's license is their overriding concern and they want it back early, that is something that may incline them to take that impaired driving plea, is when you say, I can get your license back in 60 days if we can get this plea and if you do accept it. So if that's a big issue, then that's the case there. If you win the driver's license hearing, no suspension ever starts, and then you enter a plea to impaired driving, your client's license will be protected through the duration of the process. So you have to win at the hearing, administrative hearing, and win in court. And by win, I mean either get a not guilty or enter impaired or something else below DUI. If you win the administrative hearing and you are convicted of DUI, your license will be suspended for 120 days. Right? So you have to win both, because the conviction or the administrative hearing will nip the license for 120 days on a first offense. If you lose the administrative hearing and you enter a conviction to DUI in court, it doesn't go up. So it stays at 120 days. So that's something to know. Lastly, I'll just say local knowledge is critical. Different judges, different courts are going to do different things as standard sentencing procedures. DUI fine is going to be between like $1,000 and $1,600 depending on where you are. The max on a Class B misdemeanor is just under $2,000. Usually the judges will suspend a portion of that. Impaired's usually, in whatever court you're in, whatever their DUI charge fee is, in between that $1,000 and $1,600, usually impaired's like a couple $100 less than that. And like I said, it's all different, and the fines went up last year, so they're all a little bit higher than they used to be. I want to say right now in Salt Lake City Justice Court, a DUI is like $1,640, and impaired's maybe like $1,400 or something like that. I don't know. You just have to look, and like I said, it is dependent on the judge. So, and again, things like, is this judge going to send my client to jail? Things to know, good local knowledge. I've never seen the judge in Murray send somebody to jail on a DUI. So, not to say that can't happen, but trials. Like I said, if you don't have anything to lose, go for it. You kind of got to pick your themes. An example of a trial theme would be actual physical control, right? Under the DUI statute, you have to be in actual physical control of a motor vehicle or driving it, right? Drinking and driving requires driving, go figure. So if you have an argument to make to a jury about whether or not somebody was driving, you may just want to concede impairment, right off the bat and say, yeah, my guy was drunk, too drunk to drive, that's why he wasn't, right? There's a case, and whenever you get case names wrong, you just sound like maybe, I think it's called State versus Walker. And I think that they're the Walker factors. And these are like factors that are indicative of if someone is in actual physical control of the vehicle. So it's like, where's the keys? You know, your friends are always like, oh, if you throw the keys out the window, you can't get a DUI if you're sleeping on the side of the road. That's not like a per se rule in the law. Your buddy at the bar just told you, go figure. But there's factors, it's a flexible thing, it's a jury question, right? You can argue to a jury, was this person in actual physical control of the vehicle? I had a case a while ago where somebody literally knew they were too drunk to drive, called a cab, went out to the parking lot, saw that their vehicle wasn't actually in a stall, it was just on the side of the bar, knew they were gonna leave it there, went to back it up into the stall behind them, clipped the headlight on the car by them, the police showed up and arrested them as their cab was there waiting for them. That's the type of case where you're thinking, could I argue to a jury that this person was not in actual physical control of the vehicle? That's a stretch, but that's sort of, maybe that's not as good of an actual physical control as like, is this really what the legislature meant, right? Do we really want to convict this person who is doing what we would want them to do, which is call a cab? And maybe that illustrates that you can make up your own trial themes, that you can't just challenge actual physical control, or the next thing I was going to say is challenge the chemical evidence, right? So if you have a .081 or a .08, you can challenge the machine's accuracy. One of the things you'll get at Driver's License Division and Discovery are custodian's affidavits. Every 40 days, a trooper from Highway Patrol will check each machine to make sure that it's functioning within the margin of error that's accepted by the department. It's 5% on the front end, 5% on the back end. The way they do that is they have a known sample that's at 0.1. They put that known sample into the machine, and they make sure that the machine tests within 0.005 of 0.1. So anything from 0.1 to 0.105 is going to be acceptable, right? Sometimes this is huge, right? Because if you have a 0.08 case, and this machine 40 days before your guy, or 20 days before your guy blew, and 20 days after your guy blew, when it was tested, it was reading high, then you can say, well, you know, the government's own documents show that this machine is, first of all, not accurate, and it's not accurate in that it's reading high. You should apply baseball rules. Tie goes to the runner, right? If he's at 0.08 and the machine says that it reads 0.02 high, versus 0.002 high, then you have a jury argument there for the machine's margin of error. And really, it just depends on, you just need to look at the affidavits and find out where you're sitting. Another way to challenge the chemical test, and this is like in one of those cases where maybe you think you're hosed, maybe you have a client that blew like a 0.2, but you watch the dash cam video and they're just like, yes, officer, no, I've had a couple beers, oh, I'm totally fine. And they have, you know, like pretty okay field test. Maybe technically they failed the field test, so you couldn't make a probable cause challenge, but they just look sober and they sound coherent. This is I think Scott Williams talked about this at one of the DUI seminars that I went to in St. George, and he was basically, I think he was the one that was saying, like, you equate it to, you know, if you're driving in a car, right, your buddy got a fancy car, like a brand new BMW, and you're driving down the freeway, and all of a sudden the light comes on and says, like, that the window's down, and you, like, tap on the window and it's not down, and your buddy's like, oh, my brand new car, I don't know why it's saying that the window's down, or that the door's ajar, or that, you know, whatever, that you're out of gas when you're not. Are you going to trust the light on the dashboard, or are you going to trust your senses, right? When you're hitting the window and it's clearly not down, but the car is displaying that it's down, how do you resolve that, right? So that's how you can sometimes deal with a very high BAC on a breath machine. You say, look, like something had to go wrong. Look at this guy. There's no way he can be a 0.2. He'd be falling down. How can he walk around like that? Obviously, it's a tough argument to make, but if that's all you got, that's all you got. So you go for it. Think about motions in limine, right? If you have like Miranda issues in your case, you might want to be thinking about filing a motion in limine to exclude certain statements beforehand. I think that there's a tendency to try and hide from things that are bad to your case. And I find myself doing this. Dick Burbage was an adjunct at the U when I was there, and he said one of his words of wisdom that I wrote down in law school was gravitate towards your weaknesses. And I have to remind myself of that all the time, and I think it's especially important when you're preparing for trial, because you sort of, or I anyways, sort of default into this, like, maybe if I don't say anything, the prosecutor won't notice kind of thing, you know, that my guy said, yeah, I'm way too drunk to be driving. So you want to be thinking about that stuff. Yeah, you're giving it to them pre-trial if you put it in a motion in limine. I want to keep this statement out, right? You know they're going to know about it. You know they're going to try and get it in if you want to keep it out. But you're going to have much better luck dealing with it if you're gravitating towards your weaknesses. Try and deal with that type of stuff pre-trial if you can in motions. Judges will like you more. Juries will like you more. They'll just be happier that they didn't have to wait 3 hours while you argued a motion in limine, you know, while they're sitting in the jury selection room before voir dire could start. So think of all that stuff ahead of time. Lastly, client intake, things that you should ask your client. And I did this last because I imagine that I've said things like the Baker period, right, that have left you wondering, you know, what is that? So things that you should ask your client, and hopefully this will fill in the sort of facts into the law that I've just explained. When somebody comes in, first thing I always do is I ask them where they were, what they were doing, how much they had to drink, right? I really want to know if a breath machine has a problem, because I really believe that breath machines aren't accurate. And there's serious problems with them. And if they're not administered properly, a machine that's actually reading okay, maybe, could still read wrong, right? If it's not done right. So I want to know what my client drank. I want to know when they drank it. I want to know how much of it they drank. And over what period of time, what they ate. I'm taking note of their weight, their gender. All these things are important because obviously, as probably everybody knows, like for instance, men are going to be less drunk from drinking the same amount of quantity typically that a female's going to drink. It has to do with the water content of your bodies. Men typically have more water in their bodies, and alcohol is hydrophilic, so it's going to bind to alcohol or bind to the water. Or alcohol in some of your clients' cases. It's actually, they have blood in their alcohol. So find all that stuff out. Then find out where they were going and find out why the officer pulled them over. Probably anybody who's taken criminal law knows about the exclusionary rule. There's a horrible case that came down this year in Utah in the Supreme Court where the concurring opinion basically opined for like 30 pages about why Utah shouldn't have an exclusionary rule and why we probably don't under our Constitution. Fortunately, it was just a concurrence and not binding. But it's scary to think that under the Utah Constitution there may not be an exclusionary rule someday soon. But think about that stuff. Was there reasonable suspicion for the traffic violation? Remember that reasonable suspicion is a very low standard. But find out why they were pulled over. What were they doing? Did they actually do the conduct that the officer said that they did? Right? Is that actually a traffic violation? Right? Look up the code. Find out if it's reasonable for the cop to make that stop. Because of course, if that wasn't proper, all the evidence that the officer gets after that is excluded from trial. So you need, that's the first sort of chopping point for the case. Briefly, because I know that I probably am over and running out of time, is that the standard is low, right? I had a cop that pulled a guy over for speeding. He was, it was raining, it was the middle of the night, he was watching a convenience store for burglaries. He's like an investigator who does this type of thing. This convenience store has been burgled many times. So he's parked across the street behind trees, right? Hidden from view, watching this convenience store. My guy drives by and basically it's like the University of Utah male student vehicle, right? It's like an older looking like Pathfinder or Cherokee or something like that with big tires. Drives by, he pulls him over for speeding. His police report, which was written about 25 days after this night and submitted to the record as a supplement, basically said, I was watching this convenience store, the guy drove by, he appeared to be going over the speed limit. Articulable facts, right? That's a conclusion. That's not facts to support a stop. Unless you're in South Salt Lake City Justice Court, and it is. So remember that reasonable suspicion is a low standard. However, the case I was telling you about on Draper, we challenged that stop where the officer continuously was saying that my client was weaving back and forth within her lane. Weaving within your lane is not a traffic violation. There's great case law in Utah that if they don't go over that, they don't go over the line, and arguably they need to go over it more than once because the statute says you have to stay within one lane as nearly as practical, right? So if it's not practical, like there's a piece of a tire laying in the road and you go outside of the lane and then come back and then you're weaving within your lane after that, you may have a pretty good argument that the officer shouldn't have pulled you over based on the driving pattern. So think about that motion. Next, and basically just anytime the officer does something, obviously he has to be able to justify it with some sort of prerequisite suspicion level. So the next thing, he needs reasonable suspicion that your person is under the influence of something in order to get them out of the car. As we talked about earlier, unfortunately the odor of alcohol alone is enough to get somebody out of a car. I would encourage anybody who's doing DUI to challenge that. I don't want to go into a whole big thing. The two cases that basically say that are Bennett, Lake City versus Bennett, and another city, I want to say it's Kaysville versus Maestas. But both of those cases have some cool language in them. Like I think it's in Maestas, it says, it's not necessary now for the appeals court to go into all of the facts that happened in this case, but this person did smell like alcohol. And so the question is well, what were those other facts, right? This is a totality of the facts analysis. And since they didn't say what they were, they only mentioned alcohol, I think a lot of people are interpreting that as meaning alcohol's enough. But what about alcohol in the presence of a bunch of facts that tend to cut away from impairment, right? This is the scenario I gave before. What about somebody who smells like alcohol, or alcohol's emanating from the car, but they have like 3 obviously hammered pals with them in the car, and the person that's talking to the officer is 100% cogent, right? And the officer doesn't smell alcohol coming from his breath, but just smells it coming from the car. His eyes are clear, they're not red and bloodshot. You'll never see a DUI report that doesn't say that, but imagine in a fantasy world where their eyes were red and bloodshot. And they're totally cool in every way other than the odor of alcohol. Like, I would make that motion. I want to make those motions, and maybe we'll just get a case that says no, these two, Maestas and Bennett are right, and odor of alcohol is enough, and maybe that decision already exists, and I just don't know about it, but I encourage people to challenge stuff like that all the time, because as I said, I don't even think that that's illegal, right? That's not even suspicion of illegal activity, that's suspicion of legal activity. But that being said, there's cases where alcohol is not what the DUI is for. It's for drugs or some other type of substance, spice, whatever. And so you want to look for those challenges based on odor, based on what factors the cop is relying on to get that person out of the car. That's another thing to take care of in driver's license hearings. Okay, so officer, what I'm hearing from you right now at this driver's license hearing is that the only 2 things that you noticed prior to getting this person out of the vehicle was an odor of alcohol coming from the vehicle, and their red eyes, right? Yes. And after that, after you had them out of the car, that's when you noted that the alcohol is coming from their breath, right? Yes. So things like that, hammering that out beforehand is important for motions to suppress. So they get them out of the car, they do the field tests. The 3 field tests are the HGN test, horizontal gaze nystagmus on the eyes, the walk and turn test, 9 steps out, turn 9 steps back, and then the 1-leg stand test, where they have them put their foot up parallel to the ground and hold it there for 30 seconds. You need to get the NHTSA manual and read it. It'll tell you how to do those tests properly. There's just tons of little details that go into doing that. And I mean, I could stand here and lecture about Section 8 of the NHTSA manual for like another 2 hours. I mean, literally, you just need to read it. You need to know it better than the officer that you're cross-examining. Otherwise, I mean, there's no reason to talk about field tests. But talk about those with your client, right? Find out how they think they did. Find out if the officer made any statements during the field test, like, oh, you're doing great. Oh, but now you're under arrest. After I looked at the PBT that has no evidentiary disability and saw that you were point weight 1. So think about all that stuff and really have your clients lay it out for you. At that point then, that's your sort of next decision point. Was there probable cause to make the arrest? Probably there was. As I said, there was a horrible decision that came down recently in the Utah Supreme Court, the one talking about the exclusionary rule, which seems to suggest in some weird way that the odor of alcohol in a car accident is probable cause for DUI. That's really weird. There's a great case called State versus Warwood that says that basically that no, that's not enough. Probable cause for DUI requires some sort of indicia of impaired balance. So either through field tests or somebody who's like belligerent and stumbling around, falling into the street. But you know, we'll just see on that one how that works out. So think about probable cause. Again, very low standard, right? Less than 50% sure of somebody being DUI. Then you want to be thinking about the Baker period, right? Did the officer do this observation? To do Baker, they actually have to physically inspect your client's mouth 15 minutes before they blow, and then they need to remain in their presence. That's the phrase of the page, remain in their presence for the entire period. So as far as checking the mouth, physically inspecting the mouth, I've had good success there. I had an officer that I put on the stand at a suppression hearing once, or actually the prosecutor called him, and basically, I was actually getting frustrated at the prosecutor for asking a bunch of leading questions. I was just about ready to object, and she goes, and is that when you looked in their mouth after to check Baker? And the cop goes, no. She's like, you didn't look inside his mouth for Baker? Right, you did? You know, like one doing one of these, and he goes, no, I've been talking to him for like 30 minutes since I arrested him. I knew there was nothing in his mouth, I could tell. And Judge Skanke was like, okay. Actually, I got up to argue my other points, and I opened my mouth. I said to my first point, he goes, why don't you just skip to the Baker challenge? I was like, all right. So, I mean, sometimes stuff like that happens. They have to look in the mouth. Entire period, presence being a flexible term, and entire period, I think, being the other flexible term. I've had terrible rulings on stuff like that. So, in my mind, the way that law enforcement is supposed to do a Baker check is they're supposed to arrest somebody, take them back to the station, set them down in the intox room, physically inspect their mouth, and then sit there with them for 15 minutes and do paperwork or do whatever they want. Start the incriminate yourself interview, whatever they want to do. But what you see a lot is officers will. Here's an example of a Baker motion I lost. Felony DUI, kid gets arrested, mouth check on the side of the road, put in back seat of the car. Walks up to her door, right? My argument is she's already out of his presence, right? Hops in the driver's seat, drives to the Davis County Jail from from Centerville up to Farmington at the Davis County Jail. Goes into the underground, knowing that she can't take her weapons in the jail, gets out of the car, walks around to the trunk, opens the trunk lid. Now there's glass and a trunk lid in between them. Takes off all of her stuff for a good 30, 40 seconds, walks around, opens the door, gets my guy out. So, I mean, entire, like really, entire means entire. So my understanding is that maybe that judge thought that presence means, within 100 yards. I don't know. I mean, to me, you can't observe somebody. And what they're supposed to be looking for is, did this person put anything in their mouth? Did they get anything into their mouth from the inside by belching or vomiting or any type of regurgitation, so that their mouth is clear when they blow? Because if you have any mouth alcohol or any foreign substances in your mouth, it's going to affect the machines, your liability. So, like I said, if they don't actually check, I've had a lot of success with that. If they leave the person's presence, that's where it gets a little bit more dicey in making those Baker challenges, but again, I would encourage you to make them. After Baker, then you're really just thinking about suppressing statements and stuff like that. If you've got a blood draw case, you're going to want to look at chain of custody on the blood draw to see if there's any suppression issues there. You may want to have a hearing. You may want to ask the officer about it at the driver's license hearing to find out, who took the blood, what did they do with it, where did it go, who got it back, et cetera, et cetera, et cetera. And we were talking about client interview, and so that's all stuff that, like, never let a client leave your office without saying, the officer, look inside your mouth. Right? If nothing else, the next attorney that person talks to, when they ask that question, they're going to think, well, that last person didn't know anything. This is a pretty important deal. So yeah, ask everything that you can. Get as much detail as you can about the stop, the exit of the vehicle, the field tests, the arrest itself. What happened then? Where were you? Where was the officer? Who did the inventory search? Were there assisting officers? What papers did he give you? What did you say? What did the officer say? Was the officer in a hurry? For instance, I had a highway patrol trooper who got called, literally was just like in the process of arresting my guy and got called to an accident with injuries on I-15. He was the only guy around. He was just freaking out and wanting to get out of there. Gets my guy in the back seat, just like barrels up from the side of the road off down I-15. He goes, "You don't have anything in your mouth, right?" As he's driving. You can hear it on the dash cam. My guy goes, "Nope." So we'll see if he says that while accelerating from 0 to 80 in about 400 yards, if he actually turned around with his flashlight and looked in my client's mouth, or just asked. So, any other questions? I mean, that's pretty much, yeah, obviously there's tons of details and tons of things you need to research on your own.